Today, we're talking about something that surprises a lot of parents that I talk to. What actually happens when a minor inherits or receives money through a will, insurance payout, or court settlement in Ontario, Canada? Hey, welcome everybody. I'm Kemi Adefarakan, a lawyer in Ontario, the founder of Legally Smart CEO and La Pro Law Firm, where we focus on wills, business, and trademarks. If you need help with any of those, hit me up. Many parents assume that if their child is named as beneficiary or receives an insurance payout, they automatically manage it, but that's not always the case. So let's break down what really happens and how the Office of the Children's Lawyer gets involved and how you as a parent can plan ahead. Once a minor is involved, the Office of the Children's Lawyer steps in to protect the child's interest. If the funds that your child receives are under 35,000, they usually pay directly to you. It used to be $10,000, but now it's $35,000. If the amount is over 35,000, you simply can't collect and manage it. Those funds must be paid to the accountant of the Superior Court of Justice, who will hold and manage the money for your child until they turn 18. Now, here's what many parents don't realize. Even though you are the child's parent, you are not automatically their guardian of property. Now, as a parent, you can apply to become your child's guardian of property, which gives you the legal authority to manage those funds on their behalf, but it's not automatic. That application can be refused. It's also important to know that there's a difference between being their guardian of property and being their guardian of person. I'll cover that in a separate video. Maybe once this is about, I'll do a separate video about that. If you're appointed as their guardian of property, you will need to follow what's called a management plan that outlines how the funds will be used and protected. When your child turns 18, you must show proof that any remaining funds have been transferred to them. And as their guardian, you must always be ready to pass accounts, meaning you will need help. You will need to keep detailed records of how every dollar was spent and invested. And this is something that you should think about. If there's a significant amount of money left, would you want your 18-year-old suddenly managing all that on their own? And that's why having a proper will and estate plan is so important, especially if you have minor children. A well-drafted will allows you to name a trustee to manage your child's inheritance, set the age when they can receive it, and decide when and how the money should be used. Without a plan, those decisions end up in someone else's hands, oftentimes the government. So if you have young children and don't have a will yet, this is your reminder. Planning ahead can save your family stress, court involvement, and uncertainty later. At La Pro Law, we help Ontario parents create wills and estate plans that protect their children's future. If you have any questions or you have any comments, you can reach out to me. My email is in the description below. And if you found this video helpful, please like, share, and subscribe for more practical legal tips to help you protect what matters most. I'll see you in the next video. Take care. Bye.